Firstly, I would like to acknowledge that we are meeting on the land of Fidjigal and Gadigal peoples, being the traditional owners. And I wish to pay my respects to the elders past and present and to any Aboriginal people in attendance today. I'm the chair of the panel and my name is Anna. Joining me today are Tara Cranston and Kevin Hoskin as expert members, and the community representative is Kerry. The panel has undertaken inspections of the DI items on today's public and electronic agenda. We have been provided with an assessment report prepared by council staff, who have also briefed the panel on each application. Today we have people registered to address the panel. The orders of speakers for each item, firstly councillors, objectors, and then those supporting the application, including the applicant or their representative. Each speaker will be given 3 minutes, and any extension of time will be at my discretion as chair. The panel has been provided with copies of all the submissions received in response to the public exhibition of the application and forwarded a copy of late correspondence. Therefore, there is no need for speakers to repeat all the details or all the points made in those submissions or by previous speakers. Please focus on the key points you wish us to understand. The applicant may wish to address issues raised in the council's report, including any response to conditions and the issue of space raised by any objector. We may ask questions of speakers to clarify our understanding of what's being said. We expect that each speaker will be heard in silence while they are addressing the panel, and that courtesy and respect will be observed throughout this teleconference. We ask that everyone mutes their microphone unless they are called on to speak, noting that we have the ability to mute all attendees or individuals. After hearing from the speakers on all items, the public meeting will be closed and the panel will then deliberate and make our decisions. The minutes of the panel's decisions, including our reasons, will be available on Council's website as soon as possible up to the public meeting. You should be aware that the panel meetings are recorded and the audio recordings will be uploaded to Council's website. Each member of the panel has been asked prior to the meeting to advise whether they have a conflict of interest to declare in relation to any item on the agenda. I can confirm that Tara Cranston has declared a conflict of interest in relation to the item 42 Wolseley Road, South Cootchee, and she will not participate in this matter. No other members have declared a conflict of interest in any item on the public or the electronic agendas. So the first item we have is 25 Fowler Street Crescent, and we have Matt Fortunato, who is representing 24, 26, 27, 29 and 31 Fowler Crescent.
Yes, thank you. Can you all hear me?
Yes, we can hear you.
Perfect. So as you've said, my name is Matt Fortunato. I'm a town planner on behalf of Corona Projects, who have been engaged by the property owners of number 24, 26, 27, 29 and 31 Fowler Crescent to undertake an assessment of the DA in its latest form and provide a submission to the panel on their behalf. Whilst revised drawings have been submitted since original lodgement, the amended drawings lodged August 2023 will still pose an unacceptable impact on the residential amenity of the surrounding properties and on the character of the area, and therefore cannot be supported without further revision. I'll summarise these key concerns today. However, the panel are kindly asked to re-review the submissions prepared by Corona Projects dated December 2022 on behalf of Fowler Crescent residents for full detail. With regard to view loss, the DA is likely to obstruct panoramic scenic water views. For example, the residents of number 27 Fowler Crescent currently enjoy panoramic water views from their upper floor kitchen, the most used living area of the home given its views and sunlight. The DA is expected to interrupt and visually dominate this panoramic view due to the extent of the rear extrusion and reduced rear setback. The DA will negatively overshadow its neighbours, with the northern elevation of number 27 Fowler Crescent being entirely overshadowed on the winter solstice, and also other areas shaded due to the excessive bulk of the DA. The neighbours we are representing are concerned that the Council's assessment report does not adequately justify the negative impacts and incorrectly describes the context of the site. For example, by affecting the loss of all sunlight in winter to northern living spaces at number 27, and the report also states that number 27 has a secondary living room when it in fact does not. Fowler Crescent holds an established character comprising of two-storey detached dwellings with generous rear setbacks for those dwellings on the eastern side of the street and high levels of associated privacy and amenity. The proposal in its current form will set a precedent for reducing the established high quality of residential living that the dwellings in Fowler Crescent currently enjoy and disrupting the strong pattern of single dwelling houses in the area. Suburban South Coogee is not a high-density inner-city area where someone may be expected to have compromised amenity views and outlook in favour of higher density. The amenity changes for neighbours and attached dual occupancy built form proposed under this DA reflect the expectation of an R3 or R4 land zone and cannot be supported in their current form, in our opinion. Whilst it is noted that other streets nearby feature mixed building typologies, including dual occupancies, these are not comparable or visible from the portion of Fowler Crescent immediately surrounding the development site. It's also noted that the proposed front elevation will be clearly viewed as a bulky 3-storey structure. With regards to traffic and parking, the proposed double dwelling density under this DA will undoubtedly place further pressure on the availability of on-street parking in an area where there is currently a lack of such. The additional residents introduced by the second dwelling will increase the number of people trying to find car spaces and increase the frequency of vehicle movements to and from the site. The DA exhibits major non-compliances with the objectives and controls of the Randwick LEP and DCP, including but not limited to the floor space ratio exceedance, relying on a 9.3 variation to the maximum FSR, excavation greater than 1 metre, and a rear setback significantly less than the 15-metre predominant rear building line. The DCP specifies that a setback greater than the 8-metre minimum should be provided, having regard to the existing predominant rear building line. This non-compliance is especially evident on the site plan. As these non-compliances contribute to the adverse impacts of the proposal on neighbours, a variation cannot be supported on merit. Approving this DA will have substantial cumulative impact on the surrounding area, establishing a negative development precedent as it encourages the following. Firstly, development beyond the existing established rear building line, 3 to 4 storey dual occupancy development with further parking pressures in an area that is not suited to such density, view obstruction and overshadowing, unnecessary and unjustified FSR exceedances, and a permanent change of the local character. This DA, even as revised, is still largely incompatible with the surrounding area and therefore should be adjusted to overcome the concerns of neighbours and reflect a more considerate and reasonable built form. The owners of number 24, 26, 27, 29, and 31 request that the following amendments be made. Reduction to a single dwelling house, the proposal to be adjusted to align with the predominant rear building line over number 23 and 27 Fowler Crescent on either side of the subject site. And the proposal to be adjusted to remove the basement and attic levels, relocating parking at grade on the ground floor more in line with what is established along the street. Thank you for your time.
Thank you. So just exploring this established rear building line, looking at the plans, the ground level, the build form, the living room lines up with the adjoining property to the north and is slightly forward of the one at, to the south. And it's the terrace that then goes further in. So
correct.
Is it the structure around the terrace that you're concerned at ground level?
The balconies themselves have protrusions on the side, solid protrusions. I think it's shortened blade wall, it's labelled in the drawings, which have the same effect of extending the rear building line.
Okay, so that's on the first floor level. So you don't have a concern about the ground floor level, it's the first floor level, is it?
Well, first floor level is the main concern as it impacts views, both of sunlight, more so than the ground floor, yes.
Okay, so it's principally, you're saying that it's the balcony that is non-compliant with the established rear building line.
Yeah, it's acknowledged that council's conditioned the balcony to be reduced in their consent, but this will still be well ahead of the predominant rear building line. So the rear building line would need to be pushed back and the balcony as well to conform with either side. I believe number 27 has a 15-metre rear setback and 23 has a 13, and then the proposal is going for a just over 8 metres.
Okay, thank you. Any other questions from fellow members? No. So the next speaker is John Selkirk from 27 Fowler Crescent. So Mr. Selkirk, you're raising additional issues to those that have just been raised on your behalf. Are you there? You're on mute. You're still on mute, Mr. Selfridge.
There should be a little microphone with a cross through it on your screen. If you click on that, you'll open your microphone. Perhaps we go on to another speaker and come back to it.
Well, the other one's the applicants. Okay, Mr. Selfridge, we'll just go on to the applicant, and then if you can try and sort out your sound, then we can hear from you. So we have a number of speakers on behalf of the applicant. So is one of you taking the running? Is that Mr. Boskowitz, so you're taking the running, are you?
Yes, thank you, Chair. And look, with respect to the neighbour at number 27, in the event that they are able to speak, we would like an opportunity for a right of reply. So we'll try not to take all of our time now. I might ask Mr. Tadaros, who's the architect, to come on screen, as well as Mr. Waghorn, who's the town planner.
Okay, that's fine. Just before you start, Mr. Boskowitz, just clarifying that you are not speaking in your capacity as a solicitor. You're just speaking on behalf of the.
No, it's casual Thursday. No suit, no tie. Very much on planning matters, assisting as a consultant and as a family friend of the applicant.
Okay, great.
Thank you. So we commend the report of the council staff. As you can see from the report, there have been a number of amendments made to the plans through the process. So there's been a very considered and collaborative process to try to come up with a set of documentation that forms the consent to ameliorate not only the concerns of the objectors, but also with respect to those matters that are raised in the council's DCP. And we support the recommendation, we support the conditions of consent. The reality is here today that we just want to resolve some of those issues that have been raised by Mr. Fortunato in his submissions and clarify some of those points, and thereon answer any questions that you have. I might deal with a few of them, and then I might ask Mr. Waghorn to deal with others, and otherwise the architect's here to respond to questions and just quickly go through any the design methodology of the building. Might I say, with respect to permissible uses, a dual occupancy is a permissible use in the zone. It's not, respectfully to the objector, it's not a type or form of development that one might consider to be of medium or high density use. It's a permissible use in each of those zones as well, but it's also a low density permissible use, and quite widely accepted in multiple municipalities, especially in inner city municipalities, as being a form of low density use. So we don't support any proposition that it's inconsistent with the area. In fact, there are many dual occupancies pre-existing and coming up in Randwick Municipal Council, Randwick City Council area, and we would say that the provision of dwellings and provision of stock is important for the area. With respect to view loss, the objector talks about view loss in the form of some type of retention of view, whereas the principles of tenacity talk to view sharing. Quite clearly, there have been a number of amendments made, which can be seen in the final plans, which have resulted in the retention of a substantial portion of the neighbours' views, especially number 27, insofar as they do retain panoramic views. There are some minor losses in views across side boundaries into district areas, but the substantive portion of the view, which can be seen in the figure of from pages 23 to 27, are retained. So we don't consider that there's any validity in the objections of the neighbours on the basis of the rear setback, nor on the basis of issues associated with view sharing. It almost sounds as if the objectors seek to retain all of their views, which isn't the principles don't accord with the principles internationally. With respect to the excavation basement and the traffic, it's not unusual for there to be a generation of a small amount of traffic for a redevelopment of a site, but it is consistent with the council's development control plan. The report is quite clear with respect to its support for the traffic solution. There was some works done with respect to engineering on the traffic, on the garage and the parking situation. So we commend the report and the referrals therein. I might pass to Mr. Waghorn on the issue of the rear setback and this question of predominance, because I'm not quite sure where that exactly comes from. You will note that the DCP has changed on the 1st of September 2023. This development was lodged far in advance of that. So it's a little bit strange that we're dealing with this matter with the new DCP in mind, but either way, we comply with the requirements of the DCP with respect to the control. But I might ask Mr. Waghorn to speak to that point and any other matters he wants to raise in response to the submissions of Mr. Fortunato.
Thank you. Mr. Markham.
Thank you, Madam Chair. Panel members, in terms of the rear setback, the actual numerical control in the DCP is 8 metres or 25%. We actually meet that under the proposal. We actually provide 10-metre rear setback to the first floor level balcony. When factoring in condition 2, which increases the rear setback of that first floor level balcony, we come back to a rear setback of around 11.3 metres. Now, I think the objector was referring to other buildings being set back around 15 metres. Due to the curvature of the street and the subdivision pattern, there is no real straight alignment of rear setbacks in surrounding properties. And therefore, I say that in terms of a rear setback, anywhere between 11 and probably 19 metres would be compatible with surrounding properties. It doesn't have an adverse impact on the amenity of adjoining properties, especially in terms of view loss, and is entirely appropriate and contemplated by the DCP. In terms of the overshadowing, there are some points of disagreement with the assessment report, notably the living room window of number 27 is stated that it receives no sunlight. If you actually look at the sun-eye diagrams provided with this proposal, it does actually receive solar access from 12 p.m. onwards, albeit to a smaller portion and not the entire window as in the existing situation. But as concluded by the report, we also agree that the proposal complies with the height limit, complies with the setbacks, the wall height, and number 27 is located to the south. So therefore we say overshadowing is relatively inevitable to this property, but needless to say, this proposal strikes a balance by still providing appropriate solar access to number 27, especially to the kitchen window, and will comply with council's, comply and exceed council's solar access controls to north-facing windows and to private open space. I don't think there was any other major issues that were covered by the objector that haven't been already covered by Mr. Boscovitz or in the assessment report. In general, I agree with the assessment report. I've got no further points to add unless you would like further clarifications or any further questions.
That's fine, thank you. Any questions from? Yeah, we'll ask. I'll just see if before we ask you some questions, I just was going to see if the objector, Mr. Selfridge, if you're able to get online. You've been able to.
Can you hear me by phone?
Yes. Yeah, we can hear you by phone. Okay.
Okay. Sorry about that. I don't know why, but I couldn't get through. But sorry. Yes. Once again, sorry, and thank you for the opportunity to speak. The reason why there were 14 objections to the proposed development at 25 Fowler Crescent is because of the desire by us owners to maintain the Crescent's existing amenity and serenity. Every house facing the ocean has abided by the predominant 15-metre setback, with all neighbours equally enjoying the panoramic views to the Pacific Ocean. The proposed development is attempting to change this once and for all. Just running through sort of the issues that I have with the rear setback. It is important to note that I had a senior planner from the Randwick Council visit my home in May of 2021, and they told me that any extensions to my property would not be governed by the minimum 25% or 8 metre rule, but by the existing predominant rear setback rule. The setback on every block in Fowler Crescent is without question and clear to see. Most helpful is to view it aerially, and you will have seen Corona Projects back in December of 22 providing an analysis of that. You can see that not one house has interrupted the views of others, with peaceful coexistence resulting. These setbacks have been in place since the 1960s when these homes were built. Despite all the extensions that have occurred since that time, not one house has been permitted to build beyond the building line. I would trust that a precedent has been in place and enforced by the Randwick Council over these past 60 years, and this should be considered existing and predominant as the rule stipulates. Now, the DA's intention to disregard the precedent of the building line and exploring ways to go against the intent of the legislation, my property will suffer from a loss of solar access. We've already spoken about the fact that, you know, I have no sunlight at all from 2 p.m. At winter solstice, and a complete loss of privacy. The proposed development will look straight into my spa room and also the pool area. The rule states that there is, and I quote, the need to adequately protect the privacy and sole access to the neighbouring dwellings. There is clear non-compliance here. My living room and bathroom on the first floor will have zero direct sunlight. This was actually mentioned in the application, but no solution was offered. And importantly, for loss of view, presently all neighbours along the ridge, receive 175-degree views up and down the coastline. The proposed development will take away 70 degrees of my sort of panoramic sea view, which accounts for about 40%. The council actually calls this minor, but if you actually look at the wording used in Tenacity Consulting or Ringer Council, this should be considered severe. Also, step 4 of this test case regarding the reasonableness of a property development says that, I quote, a development should be considered more reasonable if it complies with all the other planning controls. This development does not comply with the other planning controls. It breaches dominant rear setbacks, FSR limits, and excavation restrictions. And you will have noticed that the FSR has actually increased from 0.54 to 0.549 since the last submission sort of towards the end of last year. Interestingly, no high pole analysis was undertaken, even though such analysis would be considered normal in this scenario. Clearly, such an analysis would not have worked in their interest, so was not shared. And as mentioned by Corona Projects, there was a major sort of error to assumptions because they were assuming that we had a secondary living area. That's in fact a glass sunroom and was only built to go above a spa room, and we do not use it simply because it's just too hot. Then my final concern is regarding parking. The parking, the council has accepted the situation, saying that the DA will have 2 car parks for each property. However, a cursory view of Fowler Crescent in any evening will show that, you know, it's a very narrow crescent and we are chronically short of car spaces. People are even resorting to painting lines on the ground in order to attempt to squeeze more cars in. Already my neighbours and I find it very difficult to exit driveways because of the bend that exists in Fowler Crescent, and it's very, dangerous. Now, you can't say that Fowler Crescent is like Gregory Street, which is below us, which does have dual, occupancies, simply because there's a housing commission on one side of the road and there's all off-street parking there. So they only have housing on one side, whereas Fowler Crescent has housing on both sides of the street. So I don't have time to go through it all, but the applicant's SEE was riddled with factually incorrect statements. For example, just a couple.
I'll just interrupt you now because I have let you go quite a bit over time. So could you just wind it up now in terms of bringing it to conclusion, because you are quite a bit over time.
Okay, sure. look, I just think it's a very dangerous precedent from a safety perspective, because trying to exit driveways is going to be very, very difficult, and also from a financial perspective, because over time every house along the ridge will be required to go out 7 meters just to reinstate the panoramic views. This would cost tens of millions of dollars if you imagine it going right along the ridge, just in order to reinstate what we already have today. So it makes no sense at all to be right back, where we started. As the final point, anyone from the panel or council is welcome to revisit my home or any of the neighbours' homes, because we're all on board with this, that we wish to ensure the predominant setback is maintained, and we wish to ensure that the intent of the law continues to be upheld as it has over the past 60 years. We view this seriously, as evidenced by the 14 objections. Thank you, Chairperson, and the panel for your time and your attention to hear our strong objection to this DA. Thank you.
Thank you. Any questions from panel members?
No, I think so.
Yeah, that's well. Okay, Mr. Boscovich, anything further you need to add after having
just very briefly with respect to those submissions, and I won't reiterate the issue of the rear setback because Mr. Waghorn has done that, but the council's report clearly states that there's a predominant rear setback that is a range, and we are within that range. So we support the proposition of the council officer's report. With respect to view loss, I just have to respond to the objector talking about the extent of loss, and if the panel could go to page 25 through 27 or 24 through 27. And figure 13 and 14 specifically, you'll appreciate that there is some loss, but the extent of the loss is nowhere near the 40% that the neighbours talk here about. And what can be seen quite clearly is that the extent of the loss of other properties that extend along the coastline there. Well, not the coastline, along the boundaries of properties there, and what you're losing is that view towards those other properties, whereas the extent of the horizon is entirely maintained looking from the rear of the property outward, and even across part of the side of the property, across the rear of our client's property. So there is a minor impact on views, and we accept the proposition in the council officer's report that there's a minor impact on views. But when one were to assess it against tenacity, you would only get to minor, and thus principle 4 doesn't come into play. With respect to the FSR, we can see that there was a slight increase in FSR. That was because there was an agreement between the council and our client in a conference that the stairs should be counted on one of the floors. So that was the slight addition to the floor space, or to the gross floor area, that increased the floor space ratio. Other than that, we don't have any further comments unless Mr. Waghorn wants to respond to any of the points of the objector.
Right, I think the panel's got some questions. So just clarifying, just in terms of this rear setback, Mr. Waghorn, can you just confirm again? So the setback on the lower ground floor of the building, not the terrace, is how many metres?
Just give me 1 second, Madam Chair. I'll just measure. To the lower ground level, it is 8 metres.
No, to the actual building.
Oh, to the building?
Yeah, like to the living room and
to the glass line.
You'll need to.
If I could assist, I'm Rami, the architect. So to the lower ground level building line, it's actually 13 metres.
Yeah, 13.4 I've got.
Yeah, and it's slightly different depending on which boundary you're going against, but it's
Correct.
in order of 13.4 metres. Okay.
Correct.
And then on the next floor up, what's the setback to the master bedroom?
To the master bedroom?
It's 12 metres, approximately 12 metres.
Well, yeah, I get 12 and a half.
12 and a half, yes.
Sorry.
Council path condition.
Well, to cut back the balcony.
Yes. And what do you say about the draft condition to reduce the width of the balcony to the master bed, to the bedrooms?
We don't contend any issue with those, and we're satisfied by them. We accept them. It was part of a discussion that we had with council in a meeting in August, where it was suggested that we would accept that condition, but we didn't have an opportunity to amend the plan, imposing the condition that we suggested.
And then just again, the setback of the adjoining properties at the upper level, what is that? Is that the same as it says on your plans that it's 12.9 out of 8, but that's to the ground floor? Is it the same as to the upper floor?
Madam Chair, you'll see there, number 27 has that glass element that protrudes further than the actual built form. That has a setback of approximately 13.3 meters, whereas the actual wall that is adjacent to the property, which is set back further than that glass element, has a setback of about 14.7 meters.
Okay, and then on the other property, the property to the north?
Property to the north, there is a balcony element, the closest element, which is a balcony, that is set back 11.8 meters, and the glass line is set back 14.4 meters.
Okay, so, and that's on the upper level?
Correct.
Okay. Thank you. And then just a question in relation to the attic that you're proposing. It's included in GFA. What sort of attic is it? Like, what's its purpose?
It's not really big enough for
Storage.
a bedroom, so it's predominantly storage and just, just a multi-purpose. Like, for me, ideal for a kid's room or something like that. But
okay, and because you're providing that attic, your whole roof structure is much larger than it needs to be in terms of your height of your roof, et cetera, et cetera. So, and also when you look at the plans, it looks as if it's a matter of moving a wall and then you get a much bigger room up there that would be a bedroom. So how do you suggest that the panel deals with that, in the sense that you're already over your FSR, and the structure in the roof is bigger than it needs to be? And, it could be.
I'll respond to that.
Yeah.
The roof and the style and the picture of the roof meet the design objectives in the council's DCP with respect to roof design. We were able to include under the height a small area that can be utilised by the client, primarily in my instructions for an office space and storage. Under height and within the envelope of what would be a roof that would be acceptable in the property. So we would say that there's no intent or intention to increase its size. It's therefore a utility that our client, Mr. Skernick, and his father, who are building these properties for themselves, would like to use the property for. From our perspective, it's been carefully designed and carefully considered. The roof element has been changed a number of times to mitigate concerns of council with respect to its form. So this isn't where it originally started, although the size and space in the attic hasn't changed very much, but the roof form and pitch has.
Okay, and then just one other question. In relation to the ground floor plan, or the garage plan, that's below ground level, so there'll be retaining walls for the driveway, around the driveway. Is that correct? That aren't shown on the plan.
I might ask Mr. Tadros to respond to that. I'm not quite certain as to what the question was, but he might understand.
Sorry, madam, can you just restate that question?
The garage is, you go down a driveway into it.
Yes.
You see it on the photo montage. So there will be retaining walls around that driveway because the level of the green, if you look at DAA 200, will be at a higher level than the driveway.
Yes, so because the driveway is a centrally located driveway, the retaining walls will be retaining the land within our parcel of land. So it's not on any adjoining boundaries or anything like that. It's all within the front setback and the front.
Okay, and that says refer to engineering drawings, so it'll be shown in those.
For future engine.
Yeah. So other questions?
Yeah, I had going back to the attic again. So I was just wanting to clarify. So on the roof plan, it shows 6 skylights in the roof to that attic space. Are they? I think you mentioned that the intended purpose is office and storage. Is that why there's 6 skylights? Because it's intended to be used as a habitable space. And are they openable skylights? Do they get natural ventilation as well, or are they just the sunlight?
I can answer that. So the skylights are really just there just for the loftiness of that space. It's not a space that's large enough to be a habitable space. It is a utility, as outlined before, for storage, but it's a desirable space to be up there and store things, be it a little playroom or be it a small office desk. It's just the opportunity. We've designed this kind of roof form within the building roof form envelope that is allowable, and there's an ability to provide light in there. So that's really the only objective there.
Well, can I just comment, more than enough light. It's going to be very hot in there in summer with virtually 8 skylights.
Yeah. I actually do have an office with a skylight right above me, and I do agree. Having a small operable blind to screen that is very useful. So I mean that's the desired feel for that space. I mean, reducing them is not going to reduce much. It's just an option really that we wanted to have in design.
Right. Well, why do you need a full?
It does bring light.
Staircase.
Oh, sorry.
You've got a full staircase, the same as the rest of the staircases, up to a small area like that. Why do you need a main?
Well, the idea is that the skylight does allow light to penetrate deep through that light stairwell. It's a common design feature we have done for the family. We've just completed a recent due occupancy in Malabar where that was a common theme. We're just continuing that theme of letting the light fill throughout the house, fill up that void and bring light through the space. So there is a dual purpose there. It is definitely more of a light well opportunity. And it has worked with our circulation. We don't want to have attic pull down ladders and dangerous things like that. It's been a purposeful built staircase that aligns with the lower staircase. So it's just for vertical circulation and vertical light penetration throughout the dwellings.
All right, any other questions?
Yes. I had a question in relation to, I'm just trying to understand the levels. And so on figure 14, which are the montages that you submitted, I assume that relates to the amended scheme. But if I look at the top photo, the top right, which shows the proposed, it's showing at ground level I guess where the privacy screen would be for the ground level terrace, and then it shows part of the kitchen window. But when I compare that to the image on the left of existing, and we've had a look at this site, I can see the existing fence there. Now the montage, I'm just not sure if it's just missing the fence or if the floor level of the ground floor and those window heights are sitting higher than the fence. So what I'm just trying to understand is from that kitchen window, and obviously a privacy screen would be a different issue, but from the kitchen window, which I don't think is obscure glazing or privacy, it's looking from the montage that you're looking over the top of the existing fence. I'm just trying to understand the relationship. Does the floor level of the proposed dwelling sit higher? Are you going to be able to look out of that kitchen or living room window across into the rear yard of the adjoining property over the existing fence? So if you could perhaps shed some light on that, that would be handy.
I'd ask Mr. Waghorn to come on and do that. I'm not certain that these are being updated for the final plans because they were prepared as part of the original discussions on the previous iteration, but it had been decided already that they were satisfactory, and that's where then privacy and other matters came forth. But Mr. Waghorn?
Yeah, in terms of the images on figure 14, we do have the existing photos there, but the montages, of course, are just a visual representation. You know, I hear what you're saying, and I don't think they pick up necessarily all elements that are shown in the actual photo, but they do serve the purpose in allowing us to make an assessment on the view loss, and that was their primary intention. I didn't quite understand the question about the kitchen window. Are you talking about the kitchen window of number 27, Fowler, and the potential privacy
I
implications?
think it's answered if we look at on the plan, the ground floor plan 201, you've got RLs of the kitchen being 64.3, and then you've got the adjoining ground levels. Lost them now,
Yes.
but it shows what the adjoining ground levels
Sorry,
are.
it could have been, when I'm looking back at the plan, it's the living room window I can see in that montage. So window 5, W5, that in the montage, you can see part of that window above the fence height. So,
Okay.
so that's 63.16, that's the ground level. So what's the ground level of the adjoining yard?
Yeah.
So that photo montage is taken from the first floor because the number 27's living or kitchen is on the upper floor there. So we are in line with each other. And I'd just like to further highlight that the proposed number 25 Fowler Street side setback is actually 3 meters from the boundary. So although we haven't done ourselves justice as well, like in the photo montage, and the reality is that our setback is not only 3 meters, in addition to the neighbour's setback, there's a good 4 meters between the two buildings. So there is a visual relief between the kitchen window and the proposed first floor, just to help answer that question.
Yeah, and in terms of the levels, the level of the existing ground level of number 25, immediately outside that window, is RL 63.23. So it's, was it 7 centimeters difference?
Okay, so it's
so
possibly,
when factoring in, you've got a fence there, that would do the job of any privacy screen if it's required.
All right, thank you. Any other questions?
If the panel wants any certainty whatsoever with that, there's no objection to having some type of privacy screening on that window, but as Mr. Waghorn has said, it's not essential.
All right, thank you very much.
it's probably just that maybe the fence is lacking, that it's not shown as detail on the montage. Maybe something's arriving. So.
Yeah,
As
I
Mr.
think
Waghorn
so.
said, it was indicative.
In terms of montages, unless they're actually certified, et cetera, they're just a picture. Like we don't give any weight to montages. They're actually.
And what's approved are the plans, so we rely on those.
Yeah, I mean, the montage doesn't show the roof, which I think if you're over the other side of the road, you would see the roof. Anyway, thank you very much. That concludes this item. We'll move on to the next item, which is 42 Wolseley Road, South Coogee. And as I said in my opening, Cameron Clanson has a conflict of interest, so she will now leave the room. And we have David Askew, who is representing all the objectors in Wolseley Road. So if you're there, Mr. Askew.
Good afternoon, Madam Chair and panel. My name's David Haskew. I'm a consulting town planner. The landowners who I represent through Bartier Perry Lawyers are referenced on page 91 of the business paper. principally, the concerns with regard to this development relate to two issues, which is consistency with the streetscape and impact on views. What I propose to do, panel, is just to take you through the assessment report to follow along with the logic that has been applied, and then to invite you to question some of the conclusions that have been reached. Bearing in mind the two principal grounds of objection, streetscape and views, it's useful to start with the first reported DCP non-compliance, which appears on page 94 of the business paper. That's a non-compliance in relation to external wall height. What I would invite you to do is to take note of the objectives of that control, which are cited on that page, and they go to ensuring a suitable scale to the street vis-a-vis the streetscape issue, and to objective B, minimise impacts on neighbouring dwellings in terms of relevantly view loss. The elevation provided on the bottom of that page doesn't include dimensions, but what I can tell the panel is that it's the flat benched area of the site closest to Wolseley Street, which is on the left-hand side of this drawing, that the vertical measurement between that level section of the land and the roof is 9 metres in circumstances where the DCP requests a maximum wall height for steeply sloping sites of 8 metres. So bearing in mind the objective of that control in relation to streetscape and minimising impacts including view loss, I will tell you, panel, that the horizontal distance of that level section of the existing site, which results in the non-compliance, is 5.5 metres wide. And what I'm hoping to help you to see as a way forward for this proposal, which would alleviate all of the objectors' concerns, would be that if that first floor element was set back away from the level portion of the site, then in the order of about 5.5 metres, that would result in compliance with this control, and for reasons I will demonstrate momentarily, a complete removal of any view loss concerns, and would also address the streetscape issue. So that's the direction that I'm hoping to take the panel in as we work through this assessment report. Now,
yeah, I'm just going to interrupt you because you're already over time. So you presumably need extra time. How long do you think you're going to need?
About that time again, Madam Chair.
Okay, so I'll allow
I will be very fast.
Yeah, you're speaking on behalf of a number of objectors, so I'll allow that extension of time.
Thank you, Madam Chair.
No, we'll wait till the end.
Okay.
Thank you.
The view loss assessment undertaken by the council officers commences at page 117. Well, it commences earlier. I'm going to focus on number 44 Wolseley Road, which adjoins the subject site directly to the south. It's that property which is most affected by views, and it's on page 117 that that assessment occurs. I note that this is ordinarily an assessment which ought to be done by the applicant in accordance with the tenacity principles, interestingly done by the council officers. What they successfully identify is that the views in question are paragraph A of that page 117, parts of the headland, interface of water and land, iconic views to Wedding Cake Island, which are said to be high value views, and in the case of Wedding Cake Island, iconic. Now, the assessment methodology departs quite significantly from the tenacity principles. There's an inconsistency in identifying standing views versus sitting views. Ultimately, the assessment conclusion that's reached is that the side view loss to the headland area is an acceptable impact because uninterrupted views remain to the water, and citation is provided to photographs 19 and 20. Now, to appreciate the view loss that I'm concerned about, if you go to photo number 12 on page 109, through the height poles and ropes, you can see the headland in the far distance. Now that is the view that will be entirely lost even after the 1 metre by 1.6 metre splay is introduced. In circumstances where if the proposal was amended to provide a setback which allowed for compliance with the DCP maximum wall height, that view would be entirely retained. There is a very simple design solution, which is to set the first floor back 5.5 metres, comply with the DCP, preserve that view because it's easily preserved, which would also simultaneously address the streetscape irregularity raised by all of the objectors. And going to the aerial photograph on page 76, that would be a design solution which is directly referable to what the panel can see as what has been delivered on the property 2 lots to the north, which is the larger of those properties, also one of the objectors' properties.
Right.
On the basis of there being a DCP non-compliance, which hasn't been appreciated in the view loss assessment, on the basis that the view loss assessment doesn't properly follow the tenacity principles and hasn't properly discharged the test of reasonableness of the impact in circumstances where a compliant proposal would completely remove that impact, I would invite the panel not to follow the officer's recommendation. There is a development solution for this site. It's relatively easy to achieve, and it is unexpected that it hasn't been a proposal which has been advanced to date.
Right, thank you. Questions? Do you have a question?
Well, I think you might have answered it. I said, do you have a draft, or I was going to say, do you have a draft condition that would resolve the problem? Now, as I understand it, what you're alluding to is a condition that sets back the ground floor to what, 5.5 metres from the street?
No, it's the first floor. Yes.
Or is it, it's the first?
It's the top floor. Yeah, the top floor.
It's only the first floor.
It's the top floor.
That's right.
Master bedroom.
Yeah. The chamfer that is that is correct. It is the first floor, through you, Madam Chair. The chamfer that is proposed as the recommended condition does nothing in terms of protecting the interface of land and water, which is said to be a high value view in the assessment report. It doesn't bring the building back far enough to be able to recover that view, and that's obvious from the photos that are provided and the one that I took you to, particularly on page 108. So it's a much larger setback than a 1 metre chamfer that is required, but it is a design amendment which is readily attainable, would not result in any loss in floor space, wouldn't dramatically affect the functionality of the building, and it is something that I would impress upon the panel that it needs to be impressed upon the applicant that there is a solution here which accords with the tenacity principles and provides for view sharing, minimises the impacts, and brings about compliance with an objective of the DCP that specifically goes exactly to that issue.
Okay, so as I understand, where you get the 5.5 from is when you look at the north elevation and you talk about the non-compliance with the wall height. So presumably you get a measurement there of 5.5. If you look at the south elevation, which is where the view loss is actually occurring, the non-compliance with the wall height is less than that. So I'm just wondering why you get 5.5 based on the north elevation as opposed to something that's south elevation.
Yeah, it perhaps need not be the full extent of 5.5, and the reason for that is that the side viewing window of the upper level at number 44 is approximately 3.5 metres wide. So that's the view cone that exists towards the interface of land and water that we can see from the photo on photo 12, for example, on page 109. It's just bringing the building back to that sort of an alignment, which the 5.5 would bring in full compliance with the DCP. If some non-compliance was to be retained, then there would be some justification, I would think, that the purpose and objectives of the standards weren't offended, because it would be able to be demonstrated that the view loss was avoided by the proposed siting. But, Madam Chair, this is a matter that ought to be addressed by the applicant with proper, rigorous view loss analysis and design inputs. What has happened is that the applicant has put a
I'll just interrupt you.
Building envelope.
Sorry, I'll interrupt you because you're reiterating what you've already said. So I'll just check if there's any other questions from panel members. If not, we'll move on to the applicant, who's represented by Anthony Petros. So, Mr. Petros, if you're there. We got Mr. Petros.
Yep, sorry about that.
That's all right. You were, dozing.
No, the screen are minimised. Apologies for that.
It's all right.
Thanks very much, panel, for the opportunity to speak before you today. Like to support the recommendation for approval. Notwithstanding, I thought the condition to be unreasonable and unnecessary. My clients do accept that condition, which does reduce the robe in the southeast corner. In my opinion, it did provide for an incongruous streetscape outcome, but in the interest of trying to preserve some northeast views from internally of number 44, they do accept that condition. Firstly, in terms of reasonableness, it should be noted this application is 40 square metres below the FSR. Now, that's a sizable FSR amount in such a highly sought after area such as this. And as you would have seen from the site visit today and in Council's report, the scale development here is overwhelmingly 3 to 4 stories, whereby most, if not all, properties exceed the wall height that have been developed. The area where the view loss is objected by from the previous speaker is over the wall height. So in my opinion, it would be unreasonable to impose such a condition to set back that in instances where the building is under the overall height and is under the FSR by that degree. If I could just share a screen with you, is that acceptable?
Yeah.
Thank you. If you can see that, this is from the real estate, you can see dated March 2021. And also this is taken well within the living area of the adjoining property. Now, if our building is lined up in line with this and set back here, you can see that the overwhelming panoramic view, and this is deeply inside the property. The further you go towards the front, the less any impact would be. Now, this property, as a lot of the properties here enjoy, a 180 degree panoramic views to the south, to the east, to the northeast toward 20 Cake Island, and also north to Coogee Beach headlands. All of those views are retained. Now, as you know, under tenacity, it is unreasonable to expect to retain side-facing views, particularly I think in an example where it's under the height and under the FSR by that extent. In terms of the wall height and overall height, you'll note on the long sections that the building is actually well below in some parts as well. And it's due to the steeply sloping nature of these sites that the variations do occur towards the street front. Now, what this diagram, can you see the south elevation before you now?
Yes, we've got that.
Yeah, you can see the 44 is in the foreground. So actually their balcony does extend here forward of the subject site. So this does assist in retaining views, and I think it would be unreasonable in that instance to increase this setback to any greater degree. It would more or less totally compromise the amenity of that bedroom on the upper level. It would make it unusable and cause a complete redesign. As you know, the applications for alterations and additions, the upper level is well recessed, and that will read compatibly with the remaining streetscape. The report does note also there's no shadow or unreasonable privacy issues, noting there is a great deal of mutual privacy impacts in this area. Happy to answer any questions, but I think I've covered off the reasons. The other thing is that if you did increase this front setback area, it would allow for overlooking from those living room windows into our clients' bedrooms. So by providing that front alignment, which is consistent as shown in this aerial, that we're lining up with this line here along here as well. So in this instance, it'd be completely unreasonable to step this back any further, as you can see from that aerial photograph.
All right, thank you. Just a couple of questions.
Thank you.
As I understand, yeah, you said the applications for alterations and additions. So I just want to understand the extent of demolition. So basically, if you go to, I can't see the drawings numbers, but the page 3 of 17, that shows the sort of lower ground floor demolition plan, and it's pretty much all being demolished. When you go to the next level, and that then becomes the garage, then you go to the next level, the demolition plan has some walls being retained, one or couple of bit of external wall and then some internal walls. I'm not clear about the extent of the slab or the floor that's being retained, because in your sections, it doesn't actually notate whether things are being retained or being removed. So can you just clarify the extent to which, well, how do I tell when I look at, I think, page 13 of 17, what's being new and what's being retained?
Thank you. When I came on board this application, which was about a year into the assessment process, I did raise this issue with the architect, and they did provide me with a figure, and it says there's 51.7% of the existing dwelling being retained, and that the application has been determined as alterations and additions, and that included the existing slab and walls that have been retained. And you'll note that's why there's a larger ceiling height on the ground level.
So that's why the garage has an almost 5 metre ceiling height.
Correct, because of the retention of the ground floor level.
Okay. And you're saying the 51% is achieved because of the slabs and all being retained?
Slabs and walls on that ground level, yes.
In future, I think it would be good if your plans did actually clearly show the extent of demolition in terms, not just walls, but three-dimensionally in terms of the slabs, etc., just to make it clear.
Take that on board, thank you.
Yeah. And then in terms of the wall height, as I understand, you're saying the reason to some extent for allowing the exceedance of the wall height is because everyone else has done it. Is that correct? So specifically,
Sorry, no, that's one aspect of terms of being characteristic. Yeah. But importantly, the upper level is recessed, so from a streetscape perspective, the wall height doesn't generate any adverse streetscape impacts because you are viewing it from a very low level, looking upwards at that building, the uppermost building line.
Yeah,
The
but
low,
one of the objectives, as I understand it, relates to achieving, minimising impact on residential amenity, including views. Is that correct?
oh, of course, yes, but it's got to be balanced with everything else as well. That the fact that it's below at the rear and that it also maintains a lot of sunlight access to the neighbouring properties to a greater extent than a compliant development. It's also under the LEP height standard, which overrides the wall height control. And the new DCP, which is in council at the moment, also has no wall height principle in it. But in terms of the characteristic, it wouldn't look uncharacteristic in terms of streetscape. I think they have minimised views by lining up with the front alignment of the neighbouring property.
Yeah.
To expect to maintain side-facing views to predominantly the urban form of Coogee is unreasonable. The headlands will be retained from the balcony and from the front portions of that room. And that is looking due north. So everything due northeast of the Wedding Cake Island, which I think is the most iconic view of Coogee, will be fully maintained, as is the 180-degree panoramic.
Thank you. Any
Thank you.
questions?
Yes, I do. Mr. Metros, can you look at drawing 4 of 17? That's showing the excavation for the garage.
Is that the long section?
Page 4 of 17.
It's the garage.
It's showing all the deep piling to retain the soil around the excavation.
Yes, I have that.
Now, how can you retain the existing building that's above that when you have to excavate everywhere underneath it and go in with a piling machine and install all of the structural piles around the side of the excavation? How can you tell us that you are retaining the existing building?
The house is going to be underpinned. And
I beg your pardon?
the house will be underpinned. If you look at section AA, which is the long section, it's drawing 13 of 17.
Yeah, he's saying if you look at AA, which is on the screen now.
Right.
You can see the piling here and the retaining wall.
Well, it's shown as piles on the drawing I was looking at, drawing 4. How can you install all of that and say you're retaining the floor?
Well, this would be underpinned. I'm not a builder. I don't.
Yeah, no, it's on the side.
Anything like that, yeah.
It's on the side where you've gone out further than the building. The piles are actually outside.
The piles are outside the existing building.
Yeah, the applicant has just advised that there should be hand piling done, and there's been a report done by a structural engineer, and there's conditions of consent that deal with that as well. If it did come down, to avoid the consent, obviously.
I think you would be reasonable to assume that the whole thing's going to be demolished.
Well, the applications for alterations and additions, and that you can see the way it's been designed is certainly to retain the existing. If it was a new dwelling, it'd be a totally different design. You wouldn't be just limiting the upper level to this extent. You can see the extent to which the building is forward. It's been designed for alterations and additions.
Exactly. We're saying that this really isn't alterations and additions.
Anyway, that's what the application for us is. So I've got to consider that now in relations. Any further comments? No. All right. Thank you very much. That concludes that matter.
Thank you.
Cara back into the meeting. And then we'll deal with the last item. 21 Baden Street, Coogee. We have Councillor Kathy Nielsen to speak on that, but just wait until we have all members of the panel. Thank you, Councillor Nielsen.
Thank you very much, Chair, for the opportunity to address the panel regarding 21 Baden Street, Coogee. I'm Councillor Kathy Nielsen, Randwick Councillor for North Ward. I fully support the officer's recommendation for refusal. The report outlines the reasons very forcefully and extensively, so I don't need to repeat them. They're clearly set out in the report. I can also affirm that Councillor Michael Olive is of the same opinion in terms of supporting the recommendation. And we both are very supportive of any heritage acknowledgement recognition of this particular property. Thank you, Chair.
Thank you very much. Any questions? All right, thank you.
Thank you.
So that concludes the public meeting. Thank you all very much for attending. As I said in my opening, the meeting will be now closed and the panel of members will move to a closed session to deliberate and make our decisions. Those decisions and our reasons for our decisions will be placed on Council's website as soon as possible. Thank you very much. The meeting is concluded at, I don't